Okay, so we've dealt with the Islamic consideration. It's clear that from an Islamic perspective, this is something that must be done. But unfortunately, I think the thing that gets us up off our seats most of the time are financial implications. I don't know what that says about us, but it's just a reality. So maybe we do need to go through this in equal detail in order to actually show what could happen and how detrimental your finances can be affected. Okay, so controlling costs. Well, if you don't have a will in place, then it may be the case that your family sees funerals differently to yourself, and they may wish to spend a great deal of money on your burial. That may not be your wish. So in order to keep funeral costs under control, again, you specify the type of funeral that you'd want. If you don't have a will, as mentioned previously, lawyers and trustees are appointed by the government. As there is a greater amount of work and time that needs to be undertaken, the fees would increase and would be outside of your control. Again, these would all be taken from your estate. By including clauses in the will, you keep control of these costs. Avoid inheritance tax. It's a crucial issue and actually quite a political hot potato, but it's here to stay. And what we can say is that 40% of an estate above what is termed the nil rate band, and as of 2009, the nil rate band stands at £325,000 for an individual, and double that for a married couple, anything above that amount will be subject to 40% tax. And we've got a whole slide dedicated to this issue moving forwards. Avoiding interest, well, what's interest got to do with it? Most people, again, will be aware that as Muslims, we do not engage in interest-bearing transactions. But it may be the case that the people who are dealing with our estate after we have passed away are forced to go to the banks and gain a very expensive interest-bearing loan to settle a 40% tax liability. By constructing a will properly, we can avoid this prospect. And finally, the protection of assets. If you consider that an individual works throughout their life in order to build a financial base which provides their family with some level of security, it would seem a shame that some of those assets would perhaps need to be sold after their death in order to meet a tax bill with the government. In addition, it's potentially problematic if one has children who are adolescent, who are in the early teens, and who are not showing signs of maturity or being able to handle large sums of money. If that is the case, and even if this is somebody above the age of 18, you can write a will which would provide trustees with the opportunity to hold on to assets until they felt it was an opportune time to pass them on to those who have been clearly provided with a share within the Sharia distribution. So, for example, if you have a son or a daughter who's a bit of a hellraiser, you wouldn't perhaps want to give them £50,000 at this point in time. The trustees would be able to keep hold of that £50,000 until such a time that they felt that they were responsible enough and mature enough to actually use this money wisely. Okay, so what about the 40% tax then? The good news is that the vast majority of people viewing this will not have this issue, but an increasing number of us will. So for those people who this is a concern for now, or potentially will be, let's have a look at the implications of 40% tax. So the first question is, do you have a tax problem? At this moment in time, if you're single and your estate is above £325,000, then potentially yes, you will be subject to 40% tax. The nil rate band is £325,000 at the moment, but it does go up every year, but only by a small amount. And most of the time, people's homes take up a huge amount of that proportion. So I think the message is more and more of us over time will be in this 40% bracket. And ultimately, it is the law. There is no way of avoiding this. We are in a mature economy where records are kept of all assets, of all liabilities. And our house tends to form the majority of our assets. And for £325,000 for an individual, or double that for a married couple, it is likely that a lot of us will need to plan to avoid this tax. Who's going to pay the 40%? Well, to be fair, it's not going to be you because you've got other things to worry about. But your estate will be charged if there is cash in the estate. But nobody really dies with a lot of money in their accounts. So either an asset needs to be sold from your estate, again, that's not ideal, or an interest-bearing loan needs to be taken from the bank. None of these are considered favourable. And we've covered the issue of how do they pay. So the final question is, can a will avoid all of this, really? The answer to that is yes. When it comes to the issue of tax, you do need to seek professional advice. I made mention at the beginning that we provide a free wills template, but this is a simple will and doesn't deal with the issue of taxation. The issue of taxation means you need a bespoke will, a tailored will, and hence you do need to gain professional advice. Okay, finally, our third core issue. Peace of mind. So what potentially could this allude to? Well, at least you know that you've conveyed your wishes clearly, that you've made a declaration of faith within your will. People are under no illusions as to your commitment and allegiance to Islam. You've also made clear reference to your funeral wishes as well. You've implored your family not to dispute after your death. You've given them some counsel. You've reminded them of the Islamic etiquette of grieving, etc. So it's important to convey your wishes, and you can have peace of mind that you've done that. Guardianship, well, in order to avoid someone you don't like, or worse, the government taking charge of your children, simply appoint a guardian and it's probably best to make mention of it to them just in case the worst does happen. Avoid an autopsy if at all possible. Well, it is the law that an autopsy can be carried out without consent, but that is where it is necessary. If it is not necessary, then you'd wish to avoid it, and again you'd state as such. And of course, avoid delays. It's important that a family is allowed to grieve, and grieving and dealing with financial issues is a very stressful combination. So if you do have a clear will, there is no dispute. It is simply executed by your executor and people can move on. Okay, so anybody out there still think that writing a will is something that they can wait to do? So if you're concerned about the financial implications, financially you're at risk. If you're concerned about the Islamic considerations, Islamically, you haven't done what is required of you. And if you're simply concerned about some basic issues which relate to who's going to look after your kids and whether or not people know what you want after you pass away, well, that's something which you're not actually catering for at the moment either. So why not deal with all three? Especially as you've been provided with this free wills template and instruction on how to complete it. Okay, so what is it you do now? Now that you're convinced that this is something you need to do, well, we do have a guide, and the guide is called Preparing an Islamic Will. It's designed to be a 30-minute read, and everything that we've already been through is highlighted in there with further detail. So if you are academically orientated, or even if you're just curious and you'd like to know more, please do download that from the firstethical.com website. Ask yourself, do you have a tax problem? If you do have a tax problem, then you need to speak to a solicitor. If not, we'll help you create a will for absolutely no charge. Okay, at this point, there will be a small proportion of people who will have their excuses. So let's try and deal with these one by one. I'm too young to die. That may be statistically likely, but it's not law. No one's too young to die, and no one's too young to be prepared. So if you are above the age of 18, whereby you have legal title to assets, then really do look to put something in place ASAP. It costs money? Well, yes, normally it does. The service that we're providing could cost you up to £250 at a local solicitor's, but this has been provided absolutely free. I haven't got the time? Well, you have to consider that. What you put in is what you get out, but what you're putting in here is about 45 minutes, an hour's worth of research and form filling, and the result is providing you with peace of mind moving forwards for a considerable amount of time. It's an investment worth making. I don't know who to ask. Well, you do now. You can get in touch with us. There is no Sharia in the UK. Yeah, it's an interesting statement, but I'm sure all of us out there do our best to find and eat halal meat. That's not to say that everybody in the UK eats halal meat. In the same way, we can construct our wills which conform with Sharia while other people don't. Sharia says do what you want. The simple answer to that is no, it doesn't. It doesn't say do what you want. Sharia actually requires a very specific way of administering an estate. So be under no illusions. This is not something which by there is discretion. Right, so there you have it. That's the end of the presentation. There's not really much more to be said. It's taken us about 20 minutes to get through that. There is a guide that is available at the firstethical.com website under the knowledge base section. You can have a look at the third-party software which is accessible through the website and the simple wills template. So those looking for a free will, please navigate to that or website address provided with a PDF document which you can download and print, and then you can actually sit through a presentation that we put together entitled How to Complete the Free First Ethical Wills Template, and that again will take you 10 minutes to go through. So there you have it. Hopefully this has been useful. This has been a First Ethical Charitable Trust production, and we look forward to speaking to you again in the future.